The War and Peace Report. I'm Amy Goodman. In a unanimous decision, the U.S. Supreme Court has dismissed the largest class action lawsuit in history. The case involves 1.5 million current and former female employees of Walmart who filed suit in 2001, saying they were allegedly paid less and promoted less often than their male counterparts. The court found women who worked at Walmart did not have enough in common to constitute a class in a class action suit. It did not address whether Walmart had discriminated against the women. After yesterday's ruling, plaintiffs may encounter substantially more difficulty filing class action suits in all manner of cases. The majority opinion from Justice Antonin Scalia raised the threshold of certification. Scalia wrote there must be glue holding together the claims of a would-be class. Responding to the ruling in a press statement, Walmart said, quote, "The court today unanimously rejected class certification, and as the majority made clear, the plaintiffs' claims were worlds away from showing a company-wide discriminatory pay and promotion policy." But other parts of the court's ruling in the Walmart case were more divided. Justice Stephen Breyer and all three female justices, Ruth Bader Ginsburg, Sonia Sotomayor, and Elena Kagan, dissented from Scalia's broader analysis. Writing for the minority, Ginsburg noted women hold 70% of hourly paid positions in Walmart stores and just 30% of management roles. She wrote, quote, "The plaintiff's evidence, including class members' tales of their own experiences, suggests gender bias suffuse Walmart's company culture." The lead attorney for the more than 1 million female Walmart workers agreed, saying in a statement, quote, "Nothing the Supreme Court has ruled affects the power of the evidence of sex discrimination at Walmart. That evidence is as strong today as it was when it was collected," he said. To discuss this case, we're joined from Oklahoma City by the former Walmart employee Stephanie Odle. She's one of the original plaintiffs in the case, filed the gender discrimination claim with the U.S. Equal Employment Opportunity Commission against Walmart in 1999. And we're joined here in New York by Liza Featherstone, author of Selling Women Short, the landmark battle for workers' rights at Walmart. Walmart did not respond to Democracy Now!'s interview request. Let's go to Stephanie in Oklahoma City. Can you start by just responding to the Supreme Court decision?
Well, I don't understand really the legalities of it all, but I know that we're not done. We're not going to give up. This is, for me, my daughter was 3 years old when we started this case, and she's 14. So really, all she knows is her mom fights Walmart. So that's what we are going to continue to do.
Well, tell me why you brought the original case in 1999, Stephanie.
Myself, personally, I was in 9 different clubs, and I think it was 9 or 10 different clubs in 8 years. I worked for Sam's Club, a subsidiary of Walmart, and 3 different states, discriminated against in all of those states, in different regions, different directors. So I know it is they systematically discriminate. I was terminated because they wanted to make room for a man that wanted to step down and move back to where I was. He actually said goodbye on Friday. I'm going to Lubbock to be the marketing manager. I was the marketing manager. So that following Monday, they trumped up this charge and terminated me. I searched for 6 months before I could find attorneys that would actually take my case. And I was told time and time again, you can't take on Walmart. They're too big. You won't win. They don't fight fair. It'll take too much time. It'll cost too much money. Finally, I find attorneys in New Mexico that are like, okay, yeah, come on down. We sit down and talk about it, and they say to me, you know, Stephanie, you have a great case. We'll take it. We can go fight it and win, and you'll be done in a couple of years. However, they won't change. If we want to change and if you want to make a difference, then we need to do a class action. I said, well, let's go. I have a, again, 3-year-old. I want to make a difference for her. I want to make this easier for her. So we filed this class action, and now 11 years later, yes, the class action's decertified or however you say it, but I have to know we did make a difference. I did make a change. They did pay attention when we filed this lawsuit. They did start making concessions, changes, promotions, pay scaling, all of this stuff. So It may to Walmart look like they won and we lost, but if you ask me, I did exactly what I set out to do.
Stephanie, when we just read Ruth Bader Ginsburg, her comments, she didn't say discrimination doesn't exist. They decertified the class, but what does that mean for you then? Where will you go from here?
Again, I believe what our plan is, although I'm not on that strategy or whatever it is, that we sue them individually. I think they are looking at smaller classes, or I'm not sure, you know, how they said they could be certified now. But again, I don't quit. I'm not going to stop. They did discriminate against me. They are going to have the wrong is going to have to be made right.
Liza,
I can't change the fact.
Go ahead, Stephanie.
Oh, sorry. I thought, yeah, I mean, it doesn't change the fact that they have done all of these things to correct the wrongs, but it doesn't change what they did to me. And they discriminated against me, and they will have to answer for that.
Liza Featherstone is also with us. She's author of Selling Women Short, The Landmark Battle for Workers' Rights at Walmart. The significance of this tremendous win for Walmart at the Supreme Court, Liza.
It is a win for Walmart in the sense that you know, that they don't have to deal with this massive class action suit. However, Stephanie is absolutely right that that it doesn't change the discriminatory environment at Walmart, and Walmart is quite wrong, as they said in their statement, that this ruling somehow affirms that they did not discriminate against women. It does nothing of the kind, as it was never about the merits of the case. It was always about whether it should be certified as a class, and the justices agreed that it couldn't be in its current form, and as you mentioned, they disagreed about whether it should be sent back to the Ninth Circuit, whether it could be in a certified if they had followed a different procedure. It was a pretty legalistic matter. However, yeah, what this means for class actions generally, it raises the bar. It sets an example. I think that the corporate America will be very pleased, because it certainly demonstrates to workers and consumers, if you try to go after a big corporation, you know, look how futile it is. So I think they're pleased about the demonstration effect. However, I mean, it may turn out to have been somewhat narrow in its actual legal implications.
So let's talk about what you have been studying for years. You've been looking at Walmart. Your book is called Selling Women Short. Talk about, well, what Ruth Bader Ginsburg also said. Again, it's very significant. She noted women hold 70% of hourly paid positions in Walmart stores, just 30% management roles. She wrote the plaintiffs' evidence, including class members' tales of their own experiences, suggest gender bias suffused Walmart's company culture.
That's right. I mean, the plaintiffs had a lot of evidence that there was sex discrimination, systematic sex discrimination at Walmart, which is the whole idea of a class action, is to shed light and change a systematic woe. Women were paid less in virtually every single position at Walmart. No position was too minor to be exempt from sex discrimination. There were very few male cashiers, for instance. Those few were paid better than the female cashiers. That it didn't depend what region they were in. This was true all over the country. That women were promoted less easily, less often, despite the fact that the women overall had higher performance evaluations and stayed with the company longer, which you know, certainly both counts should have been in their favor. You know, and I think Ginsburg pointed to the lack of, you know, many of the personnel policies that contributed to this discrimination, that for many years Walmart didn't post available job openings in any prominent place, a break room, and so forth. But you would simply, and I think she quotes this, get a tap on the shoulder by your manager if presumably he wanted to promote you, and those people that he wanted to promote tended more often than not to be men, to be people he was sociable with. So, so I think, Ginsburg really, she kind of did understand that there was a problem here, and I think that should be taken seriously. I think that it's the stories that women like Stephanie have are also just extraordinary, and the experiences that those women have had are not changed by this ruling. I mean, Stephanie didn't mention it, but she was told, she found out that she was paid less than a male coworker when she found his pay stub. And she asked why that was, and this was when she was pregnant, expecting her first child, and she was told, "Oh, he's paid more because he has a family to support. He supports his wife and kids." And it's astounding how many women were given explanations of this nature.
What is the policy of Wal-Mart towards unions?
Absolutely no unions. They will do everything they can to fight them, and they have. There are manuals instructing managers that fighting unions is as important as anything that you do here.
Stephanie Odle, your experience in working at Wal-Mart around unions?
Being a manager, I was a manager with Sam's. I did have to attend those classes that taught us the manuals that Liza's talking about, the how to avoid the union manuals, the things that you were supposed to say, hey, we're a family, we don't need anyone else to talk for us, we have an open door, you come to us, you have a problem, we fix it. These are the things that were ingrained in our head that we tell our hourlies so that they would not seek to have someone else represent them. It was very much a big no-no to have a union. If there was, I was actually in a Red Club, I think it was called, back in 1993 or 4 in California, whenever we bought out a bunch of Pace clubs, and they turned them into Sam's clubs. So they were hot clubs with union activity. Well, they sent the most personable, the most engaged managers there that could go around and make sure that they were talking the talk. Hey, we're a family, you don't need us. What's your problem? What do you need? What can we do for you? So that we could divert those unions out of the club.